Welcome to VPG's Virtual Watercooler Chat Podcast, a platform that features professionals across a variety of industries and promotes growth mindset principles with a central pillar of championing the achievements of women. Our conversations explore a wide spectrum of backgrounds, experiences, and perspectives, creating a vibrant mosaic that enriches our collective understanding and strengthens our commitment to growth and empowerment.
Today, we're speaking with York Faulkner, founding partner of YMF Law. A veteran trial lawyer with over 30 years of experience in high-stakes global litigation, York began his career as a federal prosecutor in the U.S. Department of Justice, Tax Division, where he conducted grand jury investigations and secured convictions in complex tax fraud and conspiracy cases. He then transitioned to civil practice, becoming a go-to litigator for intellectual property disputes across a remarkable range of technologies. What truly sets York apart is his bridge between the American and Japanese legal worlds. He's periodically lived and worked in Japan since 1984, speaks and reads Japanese, and now runs a practice focused on defending Japanese companies in U.S. patent litigation and beyond. York is recognized on Managing IP's IP Stars list and co-authored the leading Japanese language treatise on FDA approvals and drug patent litigation. Let's get started.
York, how are you doing? Thank you so much for saying yes. Welcome to Virtual Watercooler Chat.
Well, Ashley, thank you. And thank you for the invitation. We used to work together every day, and it's been too long. And it's just an absolute delight to see you, to talk to you. I was just thinking, every time I hear the old adage, if you need a project done and done right, give the project to a busy person. Every time I hear that, I think of Ashley Chung. You and your team are always busy doing 100 different things. Somehow you get it all done. You get it done on time and done well. And in the past years, it's just been a joy to work with you. And I just couldn't be happier to see you and talk to you today.
Well, I really do appreciate that. Although sometimes people like, what exactly do you do?
You do everything, and that's hard to...
That's the problem. I was talking to my friend Sasha Strauss yesterday. He's a brand strategist. He's like, so what exactly is your business these days? I said, well, that's the $50 million question. My own brother does not even know what I do. But that's okay. He doesn't pay me, so it's all good, right? What do? I do PTAB filing. For the last few years, it's been more focused on ex parte re-exam. I was patent litigation all the way, so that is very similar to patent prosecution. There has been a lot of learning curve. Thank God I'm a quick learner, and I am resilient.
Well, indeed you are. In fact, I think when we worked together, it was exclusively litigation. And those were the early days when the old DC office had the basement, which was just full of boxes and paper.
We call them the dungeon.
The dungeon, right? The paper's all gone now. It's all computer database. The practice has really changed, but somehow we're managing.
Well, you know what I recall the most about you? It's the smile, but more importantly is your Western theme office in Reston with the saddle. But I really enjoy the leather chair. Whenever I have a chance, I would go in and was like, York, I'm just going to sit on this leather couch and pretend that I am in therapy.
Well, I'm glad you did. I miss the old office. When that pioneer group of us moved from the DC office out to Reston, they told me, you have a budget to decorate your office. I thought, wow, I didn't realize that. So we put in that nice pine floor and got the old Mexican furniture with the rusted hinges and everything. And it turned out pretty well. It was a pretty comfortable place.
Yeah, that's a good amount of a reminiscent of the old days. Let's talk about York and your story. Can you tell us a little bit about you and what made you decide to go to Japan to start your own firm? As if in the US it's not tough enough. Let's go across the world.
Well, there's some steps there to get to that point. A couple of real quick background points. I first went to Japan after my first year of university as a volunteer for my church for a 2-year tour of duty. And the way that works, you volunteer to go somewhere, but you don't get to decide where you're going. For example, my brother ended up going to Boise, Idaho. I opened my letter and it said, you're going to Tokyo, Japan, which was fantastic. I came to Japan for the first time in 1984 through 1986. That was during the go-go years of the Japan economy. Japan was buying up the United States and everything was possible. It was just a great time to be here and to experience Japan. In some ways, today is much more humane, I guess, would be one way to put it. It's a wonderful place, but it was a fantastic opportunity to go to a completely foreign country, to struggle with a new language, and to meet some really great people. That was my introduction to Japan, and then I went back to university. I got a degree in economics. I went to law school. I will say, just for purposes of explaining my background, although I was born born literally in downtown San Francisco. I grew up in a small town north of Sacramento in the countryside of California, riding motorcycles and horses. And my view of lawyers were the lawyers I knew. They were all solo practitioners, or they had 2 or 3 lawyer offices. And that was my vision of a legal practice. That's what I thought I would be doing with my career. I went off to law school and quickly discovered that there were such things as big firms and a whole different world out there. And one of the things that I was introduced to in my very first year were some classmates who were in law school for the purpose of becoming patent lawyers. And I had never really heard of patent law. I didn't know anything about it. But there were 2 that were really important to me in the evolution of my career. The first was Jack Pate. Jack was literally a rocket scientist. He was a senior engineer at Morton Thiokol. He took early retirement for the purpose of going to law school to become a patent lawyer. So he was a really interesting guy. And the second one was a classmate named Greg Bean. And Greg was interesting because he had a philosophy major as his undergrad degree, and he was extremely brilliant. After we got our first semester grades, there were a few of us who were doing okay. And then there was Greg, who was number 1 by a lot. And I remember having lunch one day with Greg shortly after the second semester started. And over our sandwiches, he looked at me and he said, "York, I've decided that I'm going to be a patent lawyer." I said, "Well, Greg, I know Jack. Jack was an engineer, and most of the other our classmates who were going to be patent lawyers, they're chemists or they're biologists, but you're a philosophy major." He says, "Yes, I've considered that." Greg was a very formal guy. He said, "I just got back from walking across the street to the admin office of the university. I enrolled in the physics program." So for the next 2.5 years, while maintaining his number 1 position in our law class, he got a degree in physics, and I think graduated number 1 in the physics program at the same time. Those 2 classmates made a real impression on me. I mean, if it was worth to Jack Pate giving up a promising and established career in engineering as a rocket scientist, and if it was worth the effort to Greg Bean to enroll in the physics program simultaneously with law school, all for the purpose of becoming patent lawyers, I thought there must be something to this patent law. But of course, I never really thought that would have any application to me. My degree was in economics. By the time I graduated from law school, I had accepted an offer at the U.S. Department of Justice in the tax division, and I was off to a career prosecuting tax evaders in Las Vegas and Phoenix and San Francisco and Los Angeles and Seattle and all over the Western states. It was fantastic. When I look back on it, it truly was remarkable. Within 6 months of graduating from law school, I found myself standing in front of a jury, introducing myself to the members of the jury as York Faulkner, and I'm here representing the United States of America in this case, which was pretty cool. I loved it. I loved everything about working at the Department of Justice, trying cases, jury work, grand jury work, working with the CID, Criminal Investigation Division agents at the Internal Revenue Service. It was complicated work. It was demanding. It was a lot of fun. But as I reached the 4-year mark, people started to tell me that I had a decision that I had to make in my career. Because at that point, you're kind of becoming, to recruiters and things, the most valuable in your career. And I had to decide, do I want to continue a long career in the Justice Department, or do I want to jump to private practice?
To make more money too.
And maybe make some more money, which was a real consideration. And so with that in mind, I started calling up former classmates at law school and talking to them. And when I talked to former classmates who were at big firms doing commercial work or transactional work or litigation, I kind of got the same response. How's your job? And it was usually something like, well, it's paying the bills. Not a lot of enthusiasm. But when I called Greg or Jack or some of the other patent lawyers, they loved their job. They absolutely loved what they were doing. The difference was almost night and day. And so I thought maybe there really is something to this patent law business. So I talked to Jack in more detail in particular. He had launched out. He had started his own firm, and it has grown successfully over the years, even to this day. Jack said, well, patent infringement litigation is a real growing thing right now. And there's a bunch of patent boutiques, and they're really good at patent prosecution. But what they really need are trial lawyers. I said, well, Jack, I have an economics degree. And he says, well, that's not the problem. They need trial lawyers. And he said, let's think about this. They're mostly patent boutique firms right now, but there are some general firms that have an IP practice. So maybe you could get into a general firm and then work your way over time into focusing more on IP litigation. And then just before our call ended, he said, but you're in DC, right? I said, yeah. He said, well, you should apply at Finnegan. I said, what's Finnegan? I had no idea what Finnegan Henderson was at the time. He said, wow, they're a great patent firm, great reputation, great lawyers. If you could get a job at Finnegan, you'd have a great career, he said. I wasn't too sure about that because I didn't know anything about Finnegan, and I kind of doubted that I could get a job at a pure patent firm. So I started interviewing at general firms and was getting some good progress with job interviews and even a couple of job offers and possibilities. And then the thought struck me. I never called Finnegan like Jack said I should. So I picked up the phone. I got reception. I said, may I speak to your recruiting coordinator? And she said, well, our recruiting coordinator is out this week, but you can speak to her assistant. So the phone picked up. I introduced myself. I had the whole spiel lined up. I'm at the Department of Justice. I don't have a science background, but I've done over 20 trials in 4 years. I'm a litigator. I'm interested in applying those skills to patent litigation. And she said, Mr. Faulkner, please stop. If you don't have a science background or degree, we're not going to hire you. And literally hung up the phone on me. So that kind of went as I expected it to go. A week went by and I was communicating with these other law firms. And then it dawned on me that I had never actually spoken directly to Finnegan's recruiting coordinator who was out on vacation. So I called back. She picked up the phone. I introduced myself. I did the same spiel. I'm at the Department of Justice. I've been trying cases. And she said, where are you at DOJ? I said, I'm in the tax division, criminal section. She says, well, I know you guys. She said, I used to work at the admin section at DOJ. You guys are in court all the time. You're exactly what we're looking for right now. We're trying to grow our litigation practice. She said, what are you doing today? I said, I'm flexible. We just started Casual Friday at the Department of Justice. I'm wearing my jeans. She said, oh, don't worry about that. Come on over. So I sat down with Mike Jakes and Barry Graham, had very nice discussions. I was back the next Monday for a day of interviews. And by the end of the next week, I had a job offer.
So how many people did your interview?
The Friday was informal with Mike and with Barry. And then I had the more formal set of interviews, the 2 lawyers each in the morning and then lunch. And then that was it. I probably met with 8 attorneys, probably half of which were partners and half were associates.
Let me go ahead and interrupt you a little bit. I mean, I was paralegal and I was at Howard at the time. We're finding out so many things about each other. That for all the years that we have, it's only trying to make our billable.
We were too serious.
So I started in construction litigation. I was going to really do maybe research, think tank, foreign policy type of thing. And then it was like, that doesn't really pay the bill. So I needed to do something. My professor always wanted me to go to law school. I was like, no, I don't want to do that. Ended up supporting attorneys most of my life. So started construction litigation. And then I was like, I don't really know that I want to do that. So I enrolled in the GW ABA approved paralegal program, and it was an evening class. So the firm I was working at is in Vienna, so I always have to head over to downtown K Street in the evening to finish my program. One of the adjunct professor for the program was actually doing the elective of IP law. So I took the intro to IP, and he was an associate at Morgan Lewis at Bacchus at the time. And then he told me, ever thought about doing patent or IP law? I don't know anything about that. He was like, do you know anything about construction before? Like, no. And he was like, well, exactly. You could learn that. There's a lot of transferable skills there. I said, well, you might be right. Right before I graduated from the program, he asked me the same question again. And I said, well, if you have to look into the 4 areas of IP, patent, trademark, copyright, and trade secret, which one area do you think that I would do well or should go in? I said, I don't have a technical background. For paralegals, I'm not sure that I don't have to meet your level of criteria to get in. I have litigation, which is very general. You could do anything with that. He was like, I think you'll do really well in patent. I said, but I don't have a technical background. He was like, well, you seem to have done well in construction. There's a lot of similarities on there. I said, well, there's the critical path management schedule. There's the spec specifications. He was the one that convinced me to even think that route. And at that time, I decided that maybe I should really exit the construction part. So my very first patent job that I landed was at Howard. And you know what was so appealing about that? That movie with Julia Roberts and Denzel Washington, Pelican Brief? It was filmed at the office. So I was like, I gotta go check that place. I definitely did not tell anybody about that. So I went there. It was an escalator going up, and I had my very first interview. I went there and I met the paralegal, I met the partners and associate, the paralegal manager. So there's like 6 people that I have to meet. And by the time I meet the paralegal, she asked me about e-discovery, litigation software, and at the time it was like summation. So So I was like, oh yeah, that one I could do. And now it's like relativity. So we talked and she liked me. And then there was the partner. And I was like, I have a few questions for you. How does one balance one's life at a large firm like this? He goes like, give me some answers. And then I was like, okay, that's interesting. Then the associate was rushing in and he was asking me, what substantive work do you do? I said, whatever substantive work that I do, it's still supervised by attorneys. That is under the ABA model rules. And then the partner was like, wow, that was in DC at 1299 pen. By the time that I was taking the metro back to Vienna, I got a call from the headhunter and basically said they want you.
Oh,
like
good.
literally on the metro. Howie was a GP firm. They do have an IP practice and I was hired to do IP stuff. But at the same time, some of the cases were settled and I ended up doing second request with DOJ on those cases. So basically, it's just a large amount of documents because it was in the old days, boxes after boxes that you would never see the daylight. I was like, I don't know that I really want to do this. I signed up to do patent stuff. An opportunity came up and my headhunter was like, well, it's usually when you get frustrated, you get a phone call. I was like, maybe I should try this out. So my headhunter called me and at that time it was 1299 Penn and then 1300 I Street. There was the old address long time ago.
Right.
I was like, oh, okay, I
Rings a
have
bell.
time and go over. So during the lunchtime, I went there, met the director, met the recruiting people. I was sitting there. We were getting to the point of the salary negotiation. It was not what I expected. They were like, well, this is what the market offers for your level of experience. And I said, I understand that. So I gathered my stuff, getting ready to get up. And I said, but you get what you pay for. I don't think that we should belabor any points. I don't want to waste your time and I don't want to waste my time. So thank you so much for the opportunity. I wish you well on finding the right candidate. I went and then my headhunter was calling me and said, they want you. I said, I thought that they wanted to pay the market value. Long story short, it was really interesting how I even had the nerve to say something like that. I totally hijacked your interview.
Well, you drive a hard bargain and now you're running your own business with that same tenacity. So that makes a lot of sense to me.
I think that tenacity went down a little bit. I was going through some changes at the law firm. It's not always easy. I do work for some very interesting people, but you know what? They actually do make me much more tenacious. When you know that you cannot say no and you have to get the stuff done, you have to figure out how to get it done. All those years of training, I think it was a wonderful training ground. I never knew that I was going to come out and do my own business. But if it weren't for those, I mean, Lionel, for example, he drives a hard bargain. People tell me, it's like, how do you work with such challenging attorneys? I think we have very similar work ethics. So I think in that sense, I can really appreciate what he was doing. He's very zealous to the clients. I do appreciate how much I learned. And he also was like, go get it done. I worked very closely with him. Sometimes the associate would come to me, hey, we need to figure out exactly how to work with him. And the word on the street is that we need to talk to you. I think I'm too sensitive. I worked with him almost 19 years, even from the beginning. I do think that he's a great attorney and he's very good to the client. Sometimes I was like, if it weren't for him, I would probably don't have a ground to test my grit.
You have Lionel to thank. He's a great can-do lawyer and, as you say, zealous and a hardworking guy, and clients are lucky to have him.
Let's turn back to you. Now, you were at Finnegan, and I thought that you went to another firm before you go to Japan.
I did. I went to Quinn Emanuel.
Oh, okay. So what made you decide that US is not challenging enough? So let's go to Japan. I mean, you speak the language, so that's cool. But there's so many things about doing a startup of a law firm. How do you navigate that water?
It was an interesting process. And I will just say up front, oddly, I think I have COVID to thank for it. As I had mentioned at the very beginning, this image I had of when I went to law school was the lawyers I knew who were solo practitioners or in small offices. And I had always thought that's what I would do. And I had always had that in the back of my mind that maybe later in my career, I would do my own thing. And so I was working in the Tokyo office with Quinn Emanuel attorneys here. When COVID hit, some really interesting things started to happen. Out of the blue, former clients and attorneys at other law firms started calling with specific requests. requests. They say, York, we have discovery deadlines. We need to collect documents at such and such company in Tokyo or Osaka. And we need to meet with all the custodial witnesses and interview them and get all their documents that are responsive and be able to produce them. But we can't travel to Japan because of COVID. Can you help? Not really. And for good reason. Large firms have a hesitation to take on small projects and
So you were
the
at
conflict.
Quinn at that time still. Okay.
Yes. So every time you take on a new client, you have a new conflict, and it needs to be worth taking the conflict. And if it's a small project, it's not always worth it in view of downstream business opportunities. I started to quickly realize there was an opportunity to maybe do something, and it was now later in my career, so I took the jump. I immediately cut my billing rate in half. I went from having a senior partner billing rate to a senior associate billing rate. All of a sudden, the conflict issue was really no longer an issue. I still do conflict checks. Just me, right? It doesn't take long.
You have the whole team, you yourself, and
I
you.
pull the whole team together.
The meetings of the mind.
That's right. What it has allowed me to do is, on the one hand, do these smaller projects with the reduced billing rate, and I even discount for consultation work. It's much easier for a client to pick up the phone and call with the small questions that they always have, but they would never undertake the cost or the time to reach out to their outside counsel because of the expense and the conflict checks and everything else you have to go through. So now it made me much more accessible to clients on a daily basis. I was able to continue doing what I was doing with litigation. I still do that. And so in some ways, even though I'm a solo practitioner, I still work in large litigation teams. There's always been the case that wherever I do litigation, whether it's in Delaware, New Jersey, Texas, or wherever, I have to hire local counsel. So now we look for local counsel that have the skill set that's needed for that particular case, not just being local lawyers. And so I team up with them, and that works out well. And the other thing that has worked out well in that regard, I remember working with a large pharma client several years ago, and our firm, Finnegan, was one of 3 firms working together representing the client on the case. And I remember talking to our in-house contact about that. He said, York, from our perspective, we hire lawyers, not law firms. And for this particular case, it had specific needs, and all of the needs couldn't be met from our perspective in one law firm. So we hired 3 to get the lawyers we wanted. And I never forgot that. And so now I'm in a position when a new matter comes up for a client, U.S. litigation, to sit down with the client and say, here are the technical needs, here are the geographical needs, here are the different things that we need for this case. And we have the freedom now not to look just within one law firm, but to look at the full spectrum of lawyers and choose the lawyers that we want for the case. So I've had cases now as a solo practitioner teaming up with one local counsel in litigation or 2 firms in a litigation. I just finished up a case where I was one of 3 firms litigating the matter. And the purpose was to put the right lawyers together in the team. That's been a lot of fun. So even though I'm a solo practitioner, I'm still working in litigation teams, working with other lawyers. It feels like it's always been for me in my practice. That's been very rewarding. As I mentioned, I also have the benefit of doing these smaller matters and smaller work. And one other thing I'll just mention, one thing that has surprised me is what I call inbound work that I have from Europe and from the United States primarily. And that is clients that have litigation in Japan. Now, of course, I'm not a Japanese lawyer and I don't appear in Japanese courts, but I found that there is a role for somebody like me who has kind of been bridging the 2 worlds to work and facilitate the relationship between Japanese counsel and the US client or the European client. Because Japanese litigation is different. The way briefing is done, the way the court proceeds is different. There's not an end jury trial necessarily like there is in the United States. And there's sometimes communication difficulties between the Japanese lawyer and the US client or European client. And it's not a language issue necessarily as much as it is a difference in the way the legal systems work and making sure everybody's satisfied with the end result and the end product. And that's been a very gratifying and rewarding set of work for me. And it's worked out to be about a third of what I do now.
That's really interesting. What do you think are the most common misconceptions that U.S. companies or attorneys may have about the Japanese system?
One that comes to mind very quickly is briefing and the way that briefs are written for submission to the Japanese courts. In the U.S., there's a very strong tradition of stating a theme right up front in the introduction, stating the reasons and the issues in such a way that it shows why you should win, and then building upon that as you state the facts and make your legal arguments. Japanese briefing is much more formulaic. There's the way that you set out the procedure of the case and its stance, the legal issues, the applicable law. And what in-house counsel invariably finds when they're reading the brief, and what they always say to me is, York, I had to read 20 pages before I found out what the case was all about.
But you know what? That is culture. I
It is.
study East Asian languages and cultures. My areas of study is China. So that is actually implicit versus explicit or express
Yep.
communication style. And that also has the view of time, much
Right.
more like relaxed monochronic versus polychronic. Monochronic would be like from the Western culture versus polychronic is like, oh, things are cyclical and you got some time. Whereas like, no, just get right there. Get to the point. You got to be
To the
on
point.
point. As you were saying that, I was like, oh, that's because of the culture differences.
Very much, very much. I think it probably stems from that in a very large degree. And so the kind of two roles I end up playing in this. First, in the typical situation, Japanese counsel will draft the brief in Japanese, and then they'll send it off to the translator to have it translated into English. Then the draft English is sent to the client. And invariably, the deadline for the brief is now right upon you, and there's a very short
Yes.
time for any feedback. That's a point of frustration. So I'm able to take the draft Japanese brief and translate or summarize the important points and the arguments and get that to the client very early to start getting feedback on the positions and the arguments that Japanese counsel are making. And then the second role is to find ways to make the client happy by developing the brief more in lines with the US style of briefing, putting more into the introduction, putting more emphasis on themes and arguments, and making sure they're developed in a clearly logical order in a way that may not typically be done in briefing, but also in a way that the Japanese counsel is satisfied will be acceptable to the court. And most often we're able to find that happy medium, and it tends to work out very well. And we've never had any real pushback from the courts based on the way the briefs have been drafted. So it's worked out well.
That's really interesting. I love the fact that you actually get to do things you love with autonomy. I think that's so important. I was talking to two other women founders today because we are preparing for our IP Talk brand insights for next week. And I'm having a 22-year-old moderate our panel. And so our prep today has been interesting. I was going from one thing to another. It was like 15 minutes in between. Just very interesting time. But what we really did talk about is how we have to be so resilient and adapt because we don't know one day from the next what is going to happen. You just have to be ready to fix it. I mean, I'm ready to fix it too before, but it's other people's responsibility. I might be responsible as a case manager, but ultimately it's not really my responsibility. But now it is. So how do you deal with that particular mindset shift to be a solo practitioner, shouldering that legal responsibility?
In some ways, it's been refreshing and also surprising. On the one hand, it's refreshing in the sense that in the past, when you're working within a firm and there's a structure and you're on a team, decisions and responses to clients or things are kind of a negotiated pact. So it's refreshing that I get to kind of study it out of my own mind and make a decision and recommendation. It's also a little bit scary at the same time. And the other
It's butterfly in the stomach.
And the other thing that's a little bit surprising is the assertiveness that you referenced earlier on about your response to the job offer. I found myself being much more assertive and decisive than I have been in the past, largely out of necessity because I'm a solo practitioner. The buck stops here and I have to make a decision and I have to sometimes be very direct and plain in what I'm saying. And I can't just leave it up to somebody else because there is nobody else. And again, that's within the context of working with other firms. And so many times it's still in a team context. But for the day-to-day work, running a solo practice, I think as you've pointed out and you've mentioned, kind of have to be willing to step up to the bat and take swings.
So I was like that when I was much younger. It's like, oh, that's fine. If it doesn't happen, I'll go somewhere else. But then I think there's the problem of complacency. For 19 years, you make pretty decent money. The grass is not always greener on the other side. You kind of worry about, I don't want to go try something new right now. What if I fail? What do I do? But then the key changes was that my dad passed in 2017. He passed pretty suddenly. So within 4 hours, he fell. He got to the hospital at the ER and Jess Marks. I had lunch with her today. I called her from the emergency room and I asked her, like, My dad fell. We were in the ER. She goes like, which hospital? I said Fairfax. So 30 minutes, she was there with me in the ER. And I never thought that I would lose my dad like that. So that was quite traumatic. And the firm was super nice. And even clients like Sony, they actually had people send flowers to my dad's service. Lionel made it. And you know how difficult it is to get him out of billable. Chris Isaac and a whole bunch of people that actually made it to my dad's service. I was very touched about that. My mom lives with me and I have two brothers. Being the eldest daughter, I felt that I needed to take care of my mom. And my dad told me that I should take care of my mom. I just could not work it out of my mind. I think it's been bothering me since 2017 to about 2019. And with the amount of work and the fact that I'm a workaholic, so I don't have anyone else to blame but myself. I just could not figure out a way to manage the expectation and still feel good about myself and feel like I can actually reasonably take care of my mom with my litigation schedule. So I had to figure out a way out. And I thought about maybe go to another firm, but litigation is litigation. I mean, if they tell me that I could have a balanced life, I would have to rethink it because I know that is not always the case. When you have deadline, you have to do it. So I thought I might need to pivot to be something else. So I started talking to friends. The good thing, I have a really good network. One of my friends actually left another large firm and started her own consulting company. And she was so kind and talked to me. I didn't know her. So I talked to her. She goes like, all of this, I know what you mean. We talk about from billable to clients. How did you finally pull the plug? Because most people do not expect a paralegal to go out there to start a company and to survive. So I have had people who was like, how long do you think this adventure of yours is going to take? I'm like, as long as it does. I have very marketable skills. I find my old self coming back. There was a part of me that was adjusting to the system, playing the politics, and figuring out how to fit in that grand scheme of things. And I lost myself. I got quiet. I'm no longer quiet.
Well, that's certainly not natural for you, Ashley. And I mean that in a good way. That is an interesting point. And I think from the lawyer's perspective, particularly the law firm partner perspective, as you progress through the partnership, more and more the burden of bringing in clients and being responsible for clients increases as you age up in partnerships to eventually where you get to the eat what you kill type of point, which is where you ultimately want to be because it's the best place to be and other people are depending on you. As I reflect on myself, now I'm in the ultimate eat what you kill situation.
The lone wolf.
But with expanded flexibility in terms of conflicts and other things, which is helpful. And I've been noticing a small trend in the practice with partners who are leaving, not just to jump to another large firm, but they're leaving with a small group of lawyers to start their own firm and their own practice. I think motivated for many of the same reasons that I found. You're doing nothing different. You're working and targeting the same client groups for the same type of work, but you want to do it in an environment where you have more flexibility, more freedom from the conflict structure of a large firm, and it seems to work out. And the other thing that makes it really possible now, and probably would explain some of what you're able to do, is the growth and progress of technology. I've often thought that 10 years ago, it would have been enormously difficult for me to do what I'm doing now. At the beginning, I thought, boy, at some point, I'm going to have to hire a secretary or a bookkeeper or somebody just to take care of things. But in reality, the technological tools available have taken care of all of that for me. Now I don't need to maintain a library of books. I don't have to have stacks of paper in my office because everything's electronic and databases. And I have vendor support for other aspects that I can reach out to instead of hiring an army of associates to do some work. The practice has changed, the technology has changed, and that has really made what I'm doing possible. And I think is what is facilitating some of the trends we're seeing in the practice. Not the least of which is what you're doing on your own. I'm delighted because it makes Ashley Chung available not just to Lionel, but to a broad spectrum of lawyers and firms in the country, which I think is a great thing.
I think that was unexpected when I told him that I was going to leave. He was actually probably the hardest person for me to leave because 19 years. Like I said earlier, we are very similar in terms of work ethic. So I had to really talk to myself about not letting other people down, but in in the end, I chose myself because I wanted to do something different. I really like this 6 years, how I move from year one. I literally have a client ask me this, and I will tell you what my response was. Well, where's your billing rate? Tell them whatever the billing rate is. Well, I have some large tech clients that I'd like you to support. We haven't even done engagement or anything like that. And I was like, interesting. I mean, there's not that many tech giants. I know what you're talking about. So I asked the person, yeah, just give me the patent number and then the party so I can run conflict. Well, how do I know that I can actually trust you? I said, whoa, that's an interesting question. If you don't trust me, why would you even consider hiring me? I have to run conflict. You said, why do you have to do that? I said, I support attorneys. You guys have a conflict procedure, so do I. Well, you are paralegal. I'm supervised by attorneys. If I don't have a conflict procedure, you should be worried. Because who knows what I'm going to be taking. We got through that part. He let me check and everything. And he didn't like my billing rate. And he goes, is there any room for negotiation? I said, well, it depends. What do you have in mind? And I said, are you going to pass through my invoice to the client? Or are you going to do a markup? Because I know exactly what he's trying to do. So he goes like, well, I'm going to bill you as one of my employees. I was like, oh, okay. That's fine. You could mark it up further, but I'm not changing my rate. He goes like, well, then I cannot do that. I think that he really expected that I would just accept because he's an attorney. I can be feisty. I think at that point, I just realized that this will not work out because there's no trust. I don't trust him. He doesn't trust me. So finally, I have to call him and say, hey, listen, I really appreciate you looking to hire me, engage me as a support, but I don't think this is going to work out. He was like, why? I said, there's no trust. And I think that you need to find someone that you can trust. I also need to do the same thing. I wish you a lot of luck. I wish you well. There will be someone out there that can fit this. That is incredibly hard for a non-attorney to say to an attorney. But that was one of my proudest moments.
As advice to attorneys, generally, that's good advice. But particularly thinking about my world and working here in Japan with Japanese clients, that's probably the best advice that could be given to attorneys. It is undoubtedly important to Japanese clients for credentials, for law firm history and things like that. But ultimately, what really matters here is trust, just as you were pointing out. And that's earned over time through relationships and talking and working. That's the hard work of client development here. But it's also the fun part of and rewarding part of client development, because once you achieve that level of trust here, it really works both ways and it's a very rewarding relationship. No doubt that's every bit as important everywhere else, but there is a premium on that relationship here in Japan that I've noticed.
As we close, I want to ask you a question about what advice would you give to the next generation who are thinking about building an international practice, but not necessarily know how to get their foot in?
That's a very good question. A few things come to mind right away. And I'll go back to law school. I remember one of the first days of law school, one of our professors set our little class down and he went around the room and asked everybody, what kind of law do you want to practice? And I think half of the students in the room all answered international law. Professor laughed and said, well, there really is no such thing as international law, but I wish you well, he said. And here I am. I think their subject matter of your practice is probably the most important thing. Certain subject matter like M&A, project finance, even taxation to some extent has a very broad international application. So much so that I think if you look at over half of the foreign lawyers working and living here in Tokyo, they're involved in M&A, project finance. So that is a real fertile subject matter if you're looking to be involved in an international practice. And it turns out that patent law is another subject matter that lends itself very well to an international practice, simply because companies tend to patent their technology globally, or at least in the markets that are important. And because of that, those issues tend to be litigated globally across different jurisdictions. You find yourself involved with lawsuits in Australia, in the UK or Europe, in the US and Japan, and having to coordinate all those things, even in a patent litigation practice. One thing that may not be apparent to younger lawyers when they're first thinking about launching into an international practice is the expectations. I think there is this expectation that one has to become a generalist in international patent law, for example. But that's really not the case. And I'll cite a real quick example from my own experience. I'm a member of the Tokyo Bar Association. I have a license from the Ministry of Justice, but my license is limited. I'm licensed to practice U.S. law and advise on U.S. law in Japan, and only U.S. law. So in terms of developing a practice depth and a practice focus, nothing has changed for me. I spend my time and focus on on U.S. legal issues. I'm a U.S. lawyer. I don't pretend to advise clients on Japanese law and procedure. But what is rewarding is through the experience, you become familiar with Japanese practice and legal issues enough so that you can coordinate with Japanese lawyers in parallel cases. And that's the rewarding part. That's what adds the extra international flavor to the practice. You don't hold yourself out to be a Japanese lawyer or a European lawyer. You focus on your own depth, but at the same time, you work with Japanese counsel in parallel. And that relationship is fascinating, actually, because there are subtle issues that are different among the jurisdictions. I think in terms of advice to younger lawyers, be prepared to work as a team and to be able to work with foreign counsel and try to develop good working relationships with them. And it never hurts to learn the language. A, it's rewarding, and B, it's enormously useful. The temptation is, as a native English speaker, that you can go anywhere and work in English and make it work. And I think there are several examples, even in Japan, of US lawyers who do that and do it very well. But there is a great advantage to having a good facility with the language. Being able to read is enormously helpful. To be able to correspond in Japanese through email with clients and co-counsel, being able to read native documents and not have to wait and rely on translation, whether it's actual or machine translation, whatever it may be. And most importantly, having access to decision makers at the client. Because often when you're just an English-speaking counsel in a foreign country, the client liaison will be the person who can speak English. And that may not be the decision maker. It may not even be one of the top managers. It may be a younger staff who then ends up interpreting what you have to say to the decision makers. But if you have some facility with the language, you can speak directly with the managers and the decision makers. And it just makes the relationship so much more productive and rewarding. And circling back to developing trust and long-term relationships with clients, it's really a must.
Wow. Thank you, York. This has been such an amazing time catching up. I hope that this has been as enjoyable for you as it has been for me.
Ashley, thank you.